Okay, good day everybody. I am attorney Marginal Shea B. Dixman. I will be your lecturer for court testimony, and we will be having lectures twice a week. I think it's a Monday and a Tuesday, or Monday and a Wednesday. Okay, so a brief introduction. I am a private practitioner. I've been in the practice of law for more or less 2 years, and I have been teaching for also 2 years. Since I passed the bar, I have already been teaching here at Pangasinan State University College of Criminal Justice System, I think. And also, I teach at Pan Pacific University Department of Criminology, and also Pan Pacific University College of Law. Okay, so I do private practice. Okay, so those who already know me, kilala niyo na ako kung paano ako mag-grade, how I handle classes, how I do my lectures, face-to-face. Okay, but because of the recent setup, ngayon ay online classes tayo, we will make a few adjustments. Tignan natin kung paano tayo makapag-hot seat, makapag-firing squad. Let's see how it goes. Okay, let's just explore. Anyway, also for the law students who might be watching this, okay, this lecture is specifically tailored for criminology students. So if you want to have a lecture involving the same subject for law students, you can just view or watch the other videos for law students. Okay, so now let's go with our class rules. Okay, so kung face-to-face, meron tayong attendance, class participation, quizzes. For our recent setup, we will be having only online classes where I upload video lectures. So number one, all of our lectures are pre-recorded. Okay, so na-record ko na, and then I will just be uploading it during our class schedules. Okay, initially that is the plan. Okay, upload ko sa time slot natin. Okay, but I understand the predicament of the students who might not have access to internet during our class hours. So I will upload this in our Microsoft Teams, okay, and also on Facebook and other mediums available, okay, for your consumption. Okay, so ayoko kasi siyang ma-download sana as much as possible. Ayoko siyang ma-alter. So but for your sake, sige, hayaan natin siyang ma-download. I-upload ko siya kung saan mas convenient sa estudyante. For as long as you promise me that it will just be for your personal consumption, please don't make memes, videos, or TikToks concerning these videos. Okay? Ano pa ba? Okay. So, number one, online video lectures. Okay. So, considering that most of the lectures, or not most, all of our lectures are pre-recorded, okay, before I upload the videos for the next topic. Okay, we will be having an open forum wherein you ask, okay, any questions that were covered on the videos, on the latter videos, and then I will answer. Okay, so para before ko simulan yung panibagong topics dun sa videos, okay, matapos muna, okay, kung ano man yung maagam-agam nyo doon sa unang videos na pinost ko, masagot muna natin before tayo mag-move on. Okay, so dapat may explanation muna yan. May closure muna doon sa isang topic, doon sa isang videos before ako mag-upload ng panibago. Okay, so for example, we have a schedule for Monday and then another for Wednesday. Okay, I will have an open forum on the Tuesdays wherein you can put down or write notes or write your questions and then send it to me, and I will have a question and answer, okay, wherein I answer these questions before uploading the pre-recorded videos for the next topics. Okay? Okay ba tayo dyan? Okay. Next, okay, as to attendance, I will no longer be checking your attendance. We are more results oriented, outcome oriented. So I will be giving you modules. That was the instructions. But okay, it will be hard for me to check. You know that hindi ako even in our face-to-face classes, hindi ako mahiling magpa-activities. Okay, I also don't have the time to check. Okay, so ang gagawin natin ganito. Okay, I will just be giving out a midterm examinations and a final examinations and a final class output. Okay, that final class output will be your class participation. Okay, gets. Okay, so no more quizzes, no more oral recitations whatsoever, but I will be requiring you to have a final output. What is that final output? Alam ko na marami kayong modules na ginagawa everyday. I can see your Facebook posts. I can see your rants in Twitter. Hello! Okay, some of you are my friends there. So, I understand the predicament of the students. Alam ko yung pinagdadaanan nyo. So, hindi ko kayo bibigyan ng everyday modules. Okay? What I will do instead is I will ask you, okay, to take my lectures to heart and, okay, to make your own reviewer, okay, based on the course outline that I will be giving, and submit it at the end of the semester after the final examinations. Yes, okay. So, I have already sent you the course outline. Okay, I have also uploaded it in a... I'm sorry, that was Danshal. I think she is also making her online videos and hinihiram niya yung table ko. Kaya natin siya. Okay, nasaan na nga ba ako? Okay, final output. Okay, so I will be requiring you to make a final output, and that final output will be considered as your class participation, quizzes, modules. So, instead of modules, para siyang isang napakalaking module na magagamit nyo during the board examination review. Okay? So, I have already sent to you, hindi ko alam kung inuulit ko na to, pero anyway, I have already sent to you the course outline for this subject in Microsoft Teams and in Facebook. So, you will be following that. Okay? So, kunin nyo yung course outline nyo. Kunin nyo. Okay? Okay. Hawak nyo na. Kung hawak nyo na yung course outline nyo, go to page 5 of the course outline. Okay? And then, you will see there chapter 1, general principles. Okay? Kita nyo? Okay. So, and then, after ng general principles, you see subtopics. And then, item number 1, substantive law versus remedial law. Okay, so this course outline, you will be using this to make your own reviewer. Okay. Ito yung reviewer na gagamitin nyo rin. Sana, hopefully, sa board examinations. Okay. So, ganito siya. Okay. Go to your course outline. Nakita nyo na yon, yung chapter 1, general principles, saka subtopics, substantive law versus remedial law. Okay. This is my review notes, okay, during the board examinations. Okay. So, you see, when I was still a law student, gumawa ko ng sarili kong notes. The notes that I have been using sa pagtuturo, ito yung mga notes na tinake ko nung ako yung estudyante pa lang. So, ito na yon. As in, handwritten yan. Okay. So, ito na yung ginamit ko during my law school days. Nung nag-review ako, yan na yung ginamit ko. Ngayon, na nagtuturo na ako, ito pa rin yung ginagamit ko. I just update it from time to time. Okay? Kasi nga, di ba, we are studying right now, not just to pass this particular subject, but, of course, to pass your board exams. And parating nga natin sinasabi na our end goal is not just to pass the subject, but to pass the board exams. And your preparation will start from today, your first day of classes, not just during the review. Yung preparation, hindi mo yan start sa review. You start it now. You start it today. In fact, you should have started it during the very first class, okay, na tumapak kayo sa PSU. Okay, so anyway, balik tayo dito. Okay, balik tayo dun sa final output nyo. Okay, so ang ginawa ko, when I was still a law student, my course outline ng professor, I used that course outline to make a reviewer of my own. So, what I did was to focus on one book, one resource material, and then, kung hindi malinaw yung librong yon, doon lang ako kukuha Okay? Or magbabasa pa ng ibang libro. Okay? Just one book. Okay? For this particular subject, wala akong i-recommend. Basta pumili kayo kung ano yung para sa inyo. Basta meron kayong codal, rules of word. Okay? Particularly kung ano man yung cover ng course outline natin. And then, you follow the course outline. Okay? So, itong reviewer na to, ganito lang siya kakapal. Ito yung reviewer ko sa criminal evidence. Okay. So, I made this sometime on 2016. You know. Okay, 2016. Okay, this is my notes. This was the reviewer that I used when I was reviewing, and thankfully I passed the bar. Ito lang talaga yung hawak ko for evidence. Okay, hindi na ako nagbasa ng kahit na iba. Okay, so, go to your course outline. Makikita nyo doon, general principles. So, what I did, general principles, concept of law, definition, general sense, specific sense, concept of remedial law. Okay, so ito yung mga general principles. And then, subtopics, substantive law versus remedial law. Ito yon. Substantive law versus remedial law. Okay, so, dinefine ko yung remedial law, tapos, gumawa ako ng table differentiating substantive law and remedial law. I think naka-mirror siya, but I will just insert it here. Okay. So, what you will do is to make your own reviewer based on this topic, this course outline. That will be your module. That will be your final output for me in this class. Okay. Bakit ito yung pinapagawa ko? Kesa mas stress kayo sa modules, papagawain ko na lang kayo ng isang reviewer na alam kong magagamit mo. Because in the process of making this reviewer, okay, your reviewer, okay, magbabasa ka, okay, makikinig ka sa lectures ko, okay, itatype mo or isusulat mo kung ano yung nabasa mo, narinig mo sa lectures ko, tapos babasahin mo ulit sa final exams. Kasi ito na yung gagawin mong reviewer. So, you are going to be very familiar with what you read, what you heard from me, what we discussed, from what you have typewritten, or what you have written in case it's handwritten, and what you have read again. So, pagdating ng board exam, pagdating ng review mo sa board exams, ilang beses mo nang nabasa yung reviewer na to. Kasi ikaw yung gumawa, okay? Ikaw yung nag-type, ikaw yung nag-edit, nandito lahat. So, pagdating ng board exam, halimbawa, may nakalimutan ka. Ay, nasan nga ba dito yung jurisdiction? Ay, nandito yun sa bandang dulo. Okay. Kasi ilang beses mo na siyang nabasa. Okay? So, madali na siyang balikan. Okay? So, this will be your final output. Okay? Para siyang module na minsanan lang. Pero, in effect, ginagamit mo siya. Okay? Habang nagle-lecture ako, pwede ka nang mag-type, i-type mo kung ano yung mga nakukuha mo sa lecture ko, whatever. For as long as you are convenient with your reviewer, there's no right or wrong final output for as long as you have put your effort into it. Okay lang sa akin. So, this will be your parang module. Okay? So, that will be your requirement. For examinations, sabi ko nga, I only give midterms and final examinations. Okay, my examinations are heavily based on lectures. Okay, and mahilig ako sa essay type. Okay, but considering that this is for criminology students, okay, marami tayong multiple choice questions because the board exams are in MCQ type. Okay, so, sige, lagyan natin ng MCQ. Okay. And then, what else? Ano pa bang importante? Ayun lang. Okay. So, for the class rules and requirements, yun lang yung importante. Okay. What else? For court testimony. I think wala na. If you have questions, you can just you can just ask in our in our Facebook group. Okay, mas active ako sa Facebook kasi mas madali siyang gamitin. I find Microsoft Teams very confusing or hindi ko pa talaga siya na-study. But anyway, if you have questions, just message me. Okay. Now, okay, what is court testimony? Okay. I will, to give you just a bird's eye view of court testimony. Court testimony is actually a mix of criminal law, criminal evidence, criminal procedure. Okay? So, paghahalu-haluin mo yan, there's a little bit of everything on this subject. Okay? We will start with knowing the general principles. Sa mga naging estudyante ko nasa criminal law 1, pag hindi nyo pa rin alam tong general principles, babawiin ko yung grade nyo sa criminal law 1. At, sige, mag-criminal law 1 ulit tayo. Okay. So mag-start na tayo. So, I suggest you get your course outline. Kunin nyo na yung course outline nyo. Kunin nyo na rin yung laptop nyo para makasunod kayo sa lectures. At habang nag-lecture ako dito, gagawin nyo na rin yung inyong written output. Okay? So, gagawin nyo na rin yung written output that I was referring to a while ago before ako nag-start dito sa court testimony proper. Okay, get your outline, get your books. Also, for those who are asking, I used the book of Riano. Okay, Din Riano. It's not here kasi I am filming in my room. It's in the office. Okay, but anyway, I will just be posting pictures of the book that I have used. Ito, yung Riano. And then, the rules of court. If you could not afford, or if you cannot buy the rules of court, you can just copy-paste. I think it's available online, yung rules of court. You just get the rules that we are discussing. Walang problema dyan. Okay lang yan. Okay, I think it's available online. Okay, i-type nyo lang rules of court. Okay. Okay, so let's start with our court testimony proper. Okay. So, general principles. Okay. Particularly item number 1, substantive law versus remedial law. Okay. When we say substantive law, it is one which creates, defines, and regulates right. Okay. Creates, defines, and regulates rights. That is substantive law. Okay. When we speak of remedial law, it is the branch of law which prescribes the method of enforcing or obtaining redress for any violation of or invasion of your rights. Okay. So, paano ba natin mas maintindihan yan? Ganito yan. Okay. Pag sinabi nating substantive law, okay, yan yung batas na nagbibigay sa'yo ng karapatan. Okay. Na nagbibigay sa'yo ng obligasyon. Okay. Rights and obligations. Okay. Correlative kasi yan. If you're given a right, obviously, meron siyang correlative obligation on your part. Okay. Yun yung substantive law. Pag sinabi natin na procedural law, on the other hand, ito naman, yung procedural or remedial law, pareho lang yan. Okay, remedial, procedural, pareho lang yan. Okay? It can be used interchangeably. So, pag sinabi natin remedial, okay, this is the branch of law na nagbibigay sa'yo ng proseso. Okay? Kung paano mo ma-enforce yung rights mo na binigay ng substantive law. Okay, para mas maintindihan natin, magbigay tayo ng examples. Ano ang example ng substantive law? Constitution. Okay. The 1987 Constitution. Okay. Ano ang article ang pinaka-importante na alam ninyo? Okay. Future criminologists, future police officers. Ano? It is, kahit naman hindi future police officers, bilang mamamayan ng Pilipinas, ang pinaka-importante dyan ay ang Article 3 Bill of Rights. Okay. Yung Article 3, it provides for the rights of citizens of the Philippines. Okay. So, yun ay substantive law. Okay. Ano pa ang example ng substantive law? Okay. The Revised Penal Code. Okay. The Revised Penal Code defines crimes, provides for their punishments, okay? Diba? And treats of their nature. Okay. So, the Revised Penal Code, halimbawa, Article 315, okay, defines the crime of estafa. Okay. So, it is in the nature of a substantive law because it defines, okay, a specific right, okay, or it defines a crime. Okay. So, dun tayo sa kabila. Ano naman yung remedial law? Okay. Yung remedial law naman ay nagpo-provide ng proseso. So, ano yung example ng remedial law? Rules of court. Okay. Ano sa rules of court? Specifically, court testimony. Okay. This is, okay, a classification of remedial law. Ano pa? Criminal evidence. Okay. Criminal evidence, ano pa? Criminal procedure. Okay. Yung mga yan. Okay. These are all covered by your remedial law. Kasi nagpo-provide lang sila ng proseso kung paano mo ma-enforce yung rights mo under the substantive law. Kung paano mo siya ipo-prosecute, kung paano ka makakuha ng redress for any grievances. Okay? So, gets. Okay? That is a difference of remedial law versus substantive law. Ano pa ba ang difference? Okay. Pag substantive law, meron kang vested rights. Okay. Pag remedial law, wala kang vested rights. Okay. So, substantive law, there is vested right. Kapag remedial law, no vested right. Ano ba ang ibig sabihin ng vested right? Okay. Okay. In relation to criminal law, okay, pag sinabi natin vested right, is may karapatan ka na. Okay. Yung karapatan na yun ay naibigay na sa'yo, hindi na pwedeng kunin kasi naibigay na. Kumbaga na-vest na. Vested rights nga. Tama? Okay. So, for example, okay, during the time, okay, this is a civil law case, pero ito lang yung naalala ko. Okay. This is the case of Arwego versus Court of Appeals. Okay. So, ano ba nangyari dito sa Arwego versus Court of Appeals? So, just to simplify, may mga bata, okay, they were illegitimate children, okay. Pinanganak sila during the effectivity of the civil code, okay. Tapos, nung magpa-file na sila for paternity and filiation para i-acknowledge sila ng kanilang tatay, ang in effect na ay ang family code, okay. So, ang concept ng vested rights ganito, okay. Nung time na pinanganak sila, naibigay na yung karapatan sa kanila na mag-acknowledge based on the effective law, which is the civil code. Dahil naibigay na yon sa kanila, hindi na pwedeng tanggalin. So, kahit na nung nag-file sila for filiation, for paternity and filiation, okay, during the effectivity of the family code na, okay, nung nag-file sila, family code na kasi na-amend na yung civil code. Ang mag-apply pa rin ay yung provisions ng civil code because they already have vested rights. Okay, naibigay na sa kanila yon. Hindi na pwedeng tanggalin. Okay, so because it is a substantive law, meron ng vested right. Okay, ngayon, ano naman ang example nito sa remedial law? Pag sa remedial law, no vested rights. Okay, ano ba yan? For example, okay, rules of procedure. Okay, rules of procedure kasi remedial law. Ngayon, there were amendments. Okay, there were amendments already to the rules of court sorry, for civil procedure and criminal evidence. Okay, so for example, okay, before the amendments, okay, when you file a case, hindi pa kailangan ng may judicial affidavit, hindi pa kailangan na naka-enumerate yung witnesses. That was the old rule. Okay. Ngayon, meron na siyang bagong amendment na dapat, before ka mag-file, okay, mag-file ng complaint sa korte, dapat kasama na yung judicial affidavit ng korte, dapat nakalist na yung witnesses. Question. Pwede mo bang sabihin na, ay, nung final ko yung complaint ko, yung petition ko, okay, ang in effect pa niyan yung dating rules. Okay, yung dating rules, sabi niya, hindi naman kailangan na pangalanan mo na yung witnesses mo sa complaint, na kailangan naka-attach na yung judicial affidavits. Pwede mo bang sabihin yon? Okay. The answer obviously is no. Because you have no vested rights for remedial law. Okay. And considering that the rules of court is in the nature of a remedial law, wala kang vested rights doon. Kung nagbago or na-amend yung batas, okay, magko-comply ka doon sa amendments. Agmosarag na ipasuot sa gabay mo, okay? Na dahil final mo yon during the effectivity of the old rules yon, wala kang vested rights yon, nababago yon, pwedeng kunin sa'yo. Okay? That is the concept of vested rights. Take in mind, however, na, this vested rights, i-discuss ko to later, o dun sa kabilang, subject, yung criminal law, na, if it is, for the benefit of the accused, you can apply the remedial law retroactively. Pwede mong pabalikin, Pero, kung it is not, beneficial to the accused, you cannot, That is the general rule, I will discuss that further doon sa kabilang videos, Pero mag-move on na tayo dito kasi substantive law versus remedial law lang nag-uusapan natin at ang vested rights, So, nagets nyo ba yung vested rights, yung concept ng vested rights sa substantive law tsaka remedial law? Kung nagets nyo, move on na tayo sa third, sa third difference nila, which is, pag substantive law, ito yung prospective application. Pag remedial law, ito yung retroactive application. Kailangan na naman nating intindihin kung ano ang prospective at ang retroactive or retroactive. Ngayon, those who were my students, na-discuss na natin to in detail on our criminal law 1. Pag prospective, ano ibig sabihin? Pag sinabi natin prospective, pasulong, move on. Pa-move on, mag-move on tayo. Yun ang prospective. Pag retroactive, yun yung paurong. Babalikan sa ex. Yan yung retroactive. Pag substantive, hindi pwedeng balikan si ex. Hindi yun retroactive. Gets? Pag substantive, parating move on. Kasi yun ay prospective application. So para maintindihan natin tong prospective and retroactive application, wag lang tayo dun sa move on tsaka binalikan. Wag lang yun. Masyadong baka ma-inre na naman ako dito. Complain na naman ako. So, meron tayong tatlong cases, in order to fully discuss the concept of retroactive and prospective application. Meron tayong yung anti-hazing law, meron din tayong anti-voyeurism, meron din tayong yung kay Katrina and Hayden Co case, and meron din tayong ama case, yung love bug. Since criminology students kayo, alam kong mas mag-enjoy kayo dito. So, anong nangyari doon sa Co versus Halili? In this case, Katrina Halili filed a complaint for violation of RA 9262 for emotional and psychological abuse brought about by the dissemination of the sexual video wherein she was recorded having or committing sexual intercourse with Hayden Co. So nag-video sila, tapos lumabas, hindi nila alam kung paano. So nag-file siya ng case against kay Hayden Co. Ngayon, I'm not sure if it's the judge or the fiscal, hindi ko alam. But it was dismissed. The reasoning, I think, was because there was no emotional or psychological abuse because of the fact of consent and knowledge. Sabi nila, alam naman niya na binivideo siya. So, there should be no emotional or psychological abuse. So, what happened after that? There was a Senate inquiry in aid of legislation. Di ba nagkaroon yan ng hearing sa Congress? In order to punish the acts, of, the unconsented taking of video or photos of the sexual act and distributing, reproduction, copying, etc., of the sexual act, whether or not consented o hindi nung parties to the sexual act. Now, because of the case between Katrina Halili and Hayden Co, the Anti-Voyeurism Act was legislated by Congress. So, prior to 2009 nangyari lahat to, there was no Anti-Photo and Video Voyeurism Act of 2019. So, Naipasa yun nung 2019, di ba? Kasi nga, okay, in order that future acts, okay, the same acts that were committed by Hayden Co. against Katrina be punished. Kasi there's no law punishing it. Okay? Remember, in criminal law 1, nullum crimen, nullum pena sine lege. There's no crime when there is no law punishing it. Okay? Now, this Anti-Photo and Video Voyeurism Act of 2019 is in the nature of a substantive law because it defines crime and it creates a right and a correlative obligation. Okay. So, dahil ito ay substantive law, ito ay prospective in application. Question. Okay. The acts were committed by Hayden Co. sometime in 2008. Okay. Will he be liable for violation of the Anti-Photo and Video Voyeurism Act of 2009? No. Yes or no? Kasabi lang natin, substantive law is prospective in application. Meaning, hindi siya liable. Okay? Kasi, prospective application ng substantive law. Pa-forward lang. So, it can only punish future acts, okay, that falls foursquare with the definition of the crime as defined under the Anti-Photo and Video Voyeurism Act. Okay? So, hindi na pwedeng, okay, ay, may naipasa ng batas na Anti-Photo and Video Voyeurism Act, pwede na niyang filean si Hayden. Hindi na pwede. Okay? Kasi, hindi pwedeng retroactive. Okay? Ano pa? Okay. I don't know if this is an urban legend or what, but let's explore the facts. Okay? Yung ama or love bug case. Okay? It goes like this, I think. There was a student from AMA. Okay? AMA Computer Colleges, parang gano'n. Okay? And he was able to develop a virus, computer virus. Yun yung I love you. Tapos pag kinlik mo, your data privacy will be compromised. Okay? Because of that virus, a lot of banks and other companies, okay, suffered several losses. Okay? To the point that the FBI ba? Hindi ako particular. To the point that the US, okay, already stepped in, okay, to find the culprit. Okay, tapos, na-trace nila dito, tapos nahuli si AMA computer student. Okay, now, during that time, there was still no law, okay, for Cybercrime Prevention Act. Okay. So, yung mga American officers, okay, they sought to file a case against the AMA computer student. What crime can they file against him? What case can they file against him? What? Okay. As far as I'm concerned, I think at most, okay, considering the $1 million of data privacy breaches that the virus, okay, inflicted, okay, ang na-file lang ata sa kanya is unjust vexation. Okay. Because at that time, there was still no law for cybercrime. Okay. Wala pa. Okay. So, dahil ang cybercrime defines a specific act, it's a substantive law, hindi siya retroactive. It is prospective in nature. Ano pa? Substantive. Okay. Substantive law. Anti-hazing law. Okay. Yung anti-hazing law, kaka-enact lang yon just lately. 2009, 8, something? I'm not sure. Okay. Before the anti-hazing law, all acts, okay, that were committed, okay, injuries suffered, okay, and injuries inflicted, okay, as a precondition to your membership to an organization are only serious physical injuries or murder, as the case may be, okay. Pero because of the enactment of the anti-hazing law, okay, meron na siyang specific nomenclature under the special law, okay, which is a violation of the anti-hazing law. Okay. So, yung mga yan, pwede mong sabihin na they are in the nature of substantive law and they are prospective in application. Okay? So, gets na ba natin ang remedial law and substantive law? Okay na? If you have questions, you just take them down, tapos tingnan natin. Take down notes and then sagutin natin in the Q&A. Okay? Next. Ano ba ang next sa ating... Okay. Rule-making power of the Supreme Court. Okay. The rule-making power of the Supreme Court is found under Article 8, Section 5. Tama ba? Article 8, Section 5. Okay. Of the Constitution. Okay. Copy-paste nyo yan. Kung gusto nyo i-memorize, i-memorize nyo. Pinamemorize yan sa amin. Okay. Ni Sir G. Sir Gaya. Sir Gaya was my professor in remedial law. Pinamemorize nyo sa amin yan. Pwede nyo rin i-memorize kung gusto nyo. Essentially, the rulemaking power of the Supreme Court means that, okay, the Supreme Court has the power to promulgate rules, okay, for the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, okay, practice of law, etc., etc. Okay, meaning, ang Supreme Court ang pwedeng mag-impose, okay, ng rules, okay, to implement certain substantive rights, okay. There are 3 limitations on the rulemaking power of the Supreme Court. Number 1, okay, the rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases. Okay. Simplified and inexpensive procedure in all courts for the speedy disposition of cases. And number 2, the rules shall be uniform in all courts of the same grade. And number 3, the rules shall not diminish, increase, or modify substantive rights. Okay. Okay. So, as a general rule, ang Supreme Court, pwede siyang mag-promulgate ng rules. Okay. Ang exception doon, meaning hindi pwede kapag hindi nagko-comply doon sa tatlo. Okay. Tatlong nabanggit ko kanina. Okay. Now, in relation to the rulemaking power of the Supreme Court, meron tayong tinatawag na liberal interpretation of the rules or liberal construction rule. Okay. This liberal construction rule is found in the Rules of Court, okay, which specifically provides that the rules shall be liberally construed in order to promote their objective of ensuring the just, speedy, and inexpensive disposition of every action and proceeding. Okay. Ano ba yung liberal construction rule? Ang ibig sabihin, yung rules kasi, yung mga rules of court, nandyan yan para matulungan tayo, okay, na mas mapadali, okay, yung disposition of justice para mas madaling matapos yung mga kaso. Okay. When technicalities, okay, are being used as a hindrance, okay, for justice, okay, this rule is applied, okay. Parati itong ginagamit ng mga abogado. Anyway, you just have to know that the rules should be liberally construed, okay, in order that justice might prevail, okay. Yun lang. Okay, so before we go to the third topic, which is the principle of judicial hierarchy, we should first know, okay, the concept of courts. Now, we have 2 kinds of courts, okay, yung regular courts, and we also have special courts, 3 kinds pala, regular courts, special courts, and quasi-courts. Okay, now, when we speak of regular courts, ito yung tatlo. First level courts, which is the MTC, METC, MCTC. Municipal Trial Court, Municipal Circuit Trial Courts, Metropolitan Trial Court. Okay. Yan yung first level courts. Okay. Second level courts, nandyan ang Regional Trial Courts and Family Courts. Okay. Third level courts, nandyan ang Court of Appeals and Sandigan Bayan. Okay. Fourth level courts, nandyan ang Supreme Court. Okay. Yan. Supreme Court ng pinakamataas. Pag natalo ka ba dyan sa Supreme Court, saan ka pa mag-a-appeal? Appeal to God. Okay. Now, we also have special courts. Okay. Nandyan yung Court of Tax Appeals, Sharia District Courts, Sharia Circuit Courts, and so on. Okay. And the last, quasi-courts or quasi-judicial agencies. Ito yung CSC, okay, ito yung mga administrative bodies which are given which are exercising judicial functions. Okay. For purposes of court testimony, dun lang tayo sa regular courts mag-focus. Okay. Sa first level, MTC, second level, RTC, third level, CA and Sandigan Bayan, fourth level, RTC. Okay. Now, what is... Okay, now, so when we speak of the doctrine of hierarchy of courts, it means that where courts have concurrent jurisdiction over a subject matter, okay, the case must be filed before the lowest court possible, having jurisdiction to try the case. Okay. And a direct resort to a higher court can only be allowed if you can advance a compelling reason. Okay. Why? Okay. Direct resort should be done. Okay. Now, may keyword doon, concurrent jurisdiction. Okay. Now, dito naman sa doctrine of non-interference or judicial stability. Okay. Courts of co-equal or coordinate jurisdiction cannot interfere with each other's orders. Okay. Nandito yung co-equal and coordinate jurisdiction. Okay. Kanina, concurrent. Ngayon, coordinate. Actually, this refers to the same thing. Okay. Coordinate or concurrent jurisdiction. Okay. Ang ibig sabihin ng coordinate or concurrent jurisdiction is that two or more courts possess, okay, the authority to hear, try, and decide a case. Okay. Ibig sabihin, hindi lang sa isang korte. Okay. As contradistinguished to exclusive jurisdiction, pag exclusive jurisdiction, yung subject matter na yon, yung specific na korte lang na yon ang pwedeng mag-hear, try, and decide on case. Halimbawa, okay, yung family courts. Okay, yung family courts, all matters relating to family, exclusive jurisdiction sa family courts lang. Correct? Okay. Yun ang tinatawag nating exclusive jurisdiction. Pag concurrent jurisdiction naman, ang ibig sabihin, the authority is vested in two courts or several courts. Okay? Ngayon, itong doctrine of hierarchy of courts and judicial stability refers to a situation wherein there is concurrent jurisdiction. Meaning, may dalawang korte na pareho nila na pwedeng i-hearing yung case, okay, or i-decide yung case. Okay. Dahil pareho sila na may authority, sinasabi ng doctrine of hierarchy of courts na doon muna sa mas mababang korte ipa-file. Okay? Doon naman sa doctrine of non-interference or judicial stability, ang sinasabi is, okay, pag na-file na, okay, sa isang korte, hindi na pwedeng mangialam yung ibang korte. Okay? Kasi imagine, okay, doon tayo sa doctrine of judicial stability. For example, a case is filed before RTC branch 37, for example. Okay. Tapos nag-order si judge. Okay. Sabi ni judge ganito. Okay. Tapos, okay, the parties, okay, challenge, okay, the order of the judge sa RTC. Nag-file siya sa 38. Okay. Tapos, yung order ng judge sa branch 38 is conflicting. Okay. Doon sa judge, sa order ni sa judge 37. Okay. It will result, okay, in the disruption, okay, of the courts. Okay. Kasi 'di ba, magkakaroon ng confusion. Okay. There would be interference in the administration of justice. That is why, to keep the courts stable, okay, these doctrines were implemented. Okay. So, in addition, we have this doctrine of adherence of jurisdiction or continuity of jurisdiction. Okay. When we speak of jurisdiction, kanina ko pa sinasabi, wala alam. Okay. Jurisdiction is the power or authority of the court to hear, try, and decide a case, and even to implement, okay, the decision in that particular case. Okay. Now, the doctrine of adherence of jurisdiction or continuity of jurisdiction means, okay, that once jurisdiction attached to a court. Okay. Such court, okay, has that jurisdiction until it finally disposes of a case. It could not be ousted of such jurisdiction, even by subsequent happenings, which would have, okay, prevented jurisdiction from attaching on the first place.